Hey, what's up, everybody? This is Attorney Dan Nguyen again, and I want to talk a little bit about corporate restructuring and something someone asked me um, last week, and they had one entity, one corporation with multiple retail locations in one entity, and you probably know that in California. January 1st, they came out with some new minimum wage rules. And one of the rules was if you are above 25 employees, that your minimum wage has to be at least this much. I think it's I want to say $14, $15. But if you have less than that, the minimum wage was less. And they called me and they said, hey, what if we split each of these retail locations into a different entity um, and, try to get under 25 employees. And this is this is actually pretty common, at least in the beginning. Generally, when I am advising clients, I would say, hey, each retail location should be its own entity so that you can, at the very least, limit liabilities of each location. But for the purposes of overtime and minimum wage, I looked at the labor code, and it did say that they'll the labor commission and the courts will look at what's called a reasonable test. Basically, is it under the same control of one particular one group of people, or does it have common control amongst the entities? So unlikely that if you split up your retail locations or just locations in general into different entities, with those being less than 25 employees, you probably can't get around the new minimum wage rules. Of course, every situation is a little bit different, so make sure you contact your professional attorney or CPA or both, and help them advise you on these new rules and ways that you can comply with them in this new year. All right, so this is Dan. I want to share a little bit about what I learned this week, and hope it's been helpful. So if you have any questions, feel free to reach out to me and we can do a consultation. All right, talk to you soon. Bye.